Catherine Nestor says she wants a preliminary hearing where a judge will determine if there is enough evidence to go forward with this trial. The next court date is set for October 30th. Robinson is expected to appear in person on that date. With that, we bring in Brett Tolman, former U.S. Attorney for the District of Utah and Right on Crime Executive Director. Brett, good to have you with us today. We have pictures of Catherine Nestor, who is Robinson's defense attorney. We also have the team for the other side for the prosecution, Jeff Gray and Chad Grenander. We just got our first look at these teams this morning, and we heard just that little bit from Tyler Robinson. Your thoughts on where this stands and if we will actually get a full preliminary hearing, which in Utah is in lieu of a grand jury procedure?
That's right, Martha. Thanks for having me on. I mean, this is obviously the most important case that these prosecutors, whom I know, have ever been tasked of presenting, and I'm very certain they're going to rise to the occasion. He'll be very well defended in this case, and it's important to keep in mind that the preliminary hearing. It's not surprising to me that they did not waive it, which is typical in criminal cases, but not in this instance. The defense is going to want to see a glimpse of the evidence beforehand. This allows them to see how strong the evidence is, what the government has gathered, and be able to prepare a little bit sooner in advance their defense and their strategy before committing, one way or the other as they go through the case.
So first off, a preliminary hearing is routine, but it tells us that the defense wants to test the strength of the prosecution's evidence early on. It's like saying, show us your cards before we get too far into this trial. And here is the thing, both sides have to be very careful. The defense doesn't want to push too hard and risk a procedural mistake that gets something thrown out. And the prosecution wants to lock this case airtight. That's normal legal maneuvering. But the talk about an insanity plea is where things get really interesting. To plead insanity in the US, the defense has to show that the defendant could not distinguish between right and wrong at the time of the crime. It's not just about having mental health struggles. Tons of people with mental illness still know right from wrong and are fully responsible for their actions. For an insanity plea to work, the standard is extremely high. The defense will need to prove that Tyler Robinson literally lacked the ability to appreciate the difference between good and evil, that he was disconnected from reality to the point that he didn't understand what he was doing. That's a very, very tough sell. Now, here's the problem for Robinson's defense team: planning. We already know from evidence that he planned this assassination in advance. A text message between him and his roommate shows that he was planning this a week before it happened. That proves premeditation. And beyond that, he was interacting normally with friends, family, and others right up until the crime. That's all evidence that he could function in society and knew what he was doing.